Hi, I'm Akash Kashyap, and today we're going to talk about another agreement common to the entertainment industry, the work for hire agreement. Now, oftentimes when you're creating your work, you're not going to be able to do every aspect of it yourself. And this is especially true in more involved productions like audiovisual mediums or music or performances or so on and so forth. Now, in these cases, oftentimes the direction or the creation or the main artist is going to be one or a handful of individuals out of all those contributing to the work. However, given the way that copyright works and how it can automatically attach to creative works, it can be troublesome to include those individuals in the production that aren't intended to be owners of the work itself. In order to allow contributions from employees, contractors, and subordinates that aren't supposed to own the copyright, you have to engage in a very specific type of agreement, the work for hire agreement. So today we're going to look at what a work for hire agreement is, how it's formed, and key features of the agreement.
A work for hire agreement is a statutory tool by which the first author of a copywritten work is determined and is often separate from the individual actually making the creative development, performance, or work that is involved. Now, unlike the assignment of ownership of a copyright, which can be done through an ordinary contractual relationship, this is something that occurs only through statute. Now, this relates generally to the additional rights, such as reversion or droit moral, that apply to the first author. And in order to have those assigned properly, you need to have a proper, statutorily compliant work for hire agreement. In essence, the work for hire agreement takes advantage of a small and incredibly narrow exception to the standard conception of copyright, which is the traditional way in which copyright is developed and is treated by law.
Now that we've got a basic idea of what a work for hire agreement is and how it's formed, let's look at some key features of the work for hire agreement, what it can do, what it can't do, and what makes a work for hire agreement different from any other form of agreement.
As a statutory concept, there are some key requirements, key elements that make a work for hire contract valid. So let's go through these in order. First, the agreement that designates a work as a work for hire must be made prior to the creation of the work. The contributor has to sign the agreement that designates the work as a work for hire before they contribute to the work. It's not something that can be done retroactively. Similarly, the creation of the work has to be in accordance with the contract. For example, if you hire someone to play backing vocals on your song, if they then start contributing as a drummer, as a arranger, start providing fronting vocals, or perform any other instrument, they are not contributing in accordance with the contract. And those creative elements that are added outside the realm of the agreement that was created will not be covered by the work for hire contract. Now, the combination of these two requirements for a valid work for hire agreement does make it important to have it in place both evidentiary and legal stopgaps within the agreement to try to claw back ownership over any work that exceeds the agreement or that was created or developed prior to the agreement. Now, when it comes to the evidentiary stopgap, first, there needs to be the employee's acknowledgement. This acknowledgement will have to acknowledge that nothing that they contribute was created prior to the creation of the agreement, that they are only going to operate within the bounds of the agreement, and anything that they contribute should be construed in such a manner, and that they are willingly giving up their rights over the work by creating it as a work for hire. On the legal stopgap side, you need to have both an employee waiver whereby they waive any rights over the work that they're contributing, whether or not it's a work for hire. And as a final failsafe, there needs to be an employee assignment, where if there is any element that they contribute which cannot validly fall within the ambit of the work for hire, you still don't want them to be able to claim ownership and to be put in the position of having to buy the rights off of them for their contribution or scrap the song. So the final legal stopgap is an assignment agreement, whereby anything that falls outside the bounds of the work for hire, anything that cannot be demonstrated by the evidentiary stopgap and doesn't fall within the ambit of the waiver, they will, for no consideration, transfer over to you as part and parcel of this agreement. Now, these two stopgaps are not 100% effective, which is why it is essential to make sure that your work for hire agreement is drafted carefully and that the production and the contribution of the contractor occurs within the bounds of that agreement.
So as you can see, the work for hire agreement is an essential agreement that helps delineate the difference between those that are working for you while you are producing your work and those that are collaborating with you on your work. This is a very specific agreement that has some key statutory requirements without which the agreement will fail, and your collaborators may include those intended to be contractors. In order to make sure that your agreement fits all of the statutory requirements of a work for hire agreement and that your contractors don't become inadvertent collaborators or owners of the copyright to your work, consult an intellectual property or entertainment attorney.
Thank you for watching. If you like this video, please like, comment with your thoughts, share it with friends and family, and subscribe to see more content.